Buckle up, guys, because we're starting with Eric Martin, the self-proclaimed living man who thinks court rules don't apply to him. The intro sets the stage for 5 separate hearings, and Eric's already facing multiple traffic charges plus a domestic violence case. Before we even get to the meat of it, you can feel the tension. His confidence is sky high, but the courtroom's patience? Already running on fumes.
Okay, in the matter of people versus Eric Martin. Mr. Martin, can you hear us?
Yes, can I get the first case number of this so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
241-388 SM.
241, what else?
38 SM.
38?
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see. January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said that right to be. So.
Okay. I'm gonna let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're gonna do today.
Right, so I would like to talk to him right about how the case should be dismissed based on there's no evidence.
Eric immediately challenges the process, claiming due process violations and saying he never even got a ticket. The judge calmly asks for a case number, but Eric's more interested in pushing his sovereign people narrative. It's his first big standoff, and he's convinced this will end in his favor. The judge decides to send him to the prosecutor instead, perhaps hoping logic might break through. Spoiler, it won't.
A matter of people versus Eric Martin.
Okay, thank you.
Mr. Martin, can you hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, want to put your appearance on record?
Hey, good morning, Your Honor. Or good afternoon, Your Honor. Omar Shah on behalf of the people, please, 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or a judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed I'm consenting to any of these proceedings, you know. I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackleford, who did not give me a personal bond. I want arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
Back from the prosecutor's room, and nothing's changed. Eric refuses to pick jury or bench trial, likening it to slavery. This is a classic sovereign tactic, stalling and making wild comparisons to avoid giving direct answers. The room is stone silent, waiting for the judge's next move. You can sense the slow build toward the sarcasm that's about to drop.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hello, I have an objection. I have a motion to make that I have a right to a personal bond.
You file that motion in writing, and I'll take a look at it.
I already did file it with the.
In the meantime, I want you to go with the sheriff, and he's gonna take care of you.
Hold on, object. I have some. I already
Put 'em
filed
on,
it with the court.
put 'em on
I'm
mute.
making that motion now. I'm making that demand actually now because it's a constitutional right to be
Alright.
without guilty.
All right.
All right, then I'll be taking your job. How about that? Because you violate my constitutional right, and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness, and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold office. But don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out. They're not above the Constitution.
Eric demands arrests, yes, arrests, of both the arresting officer and Judge Shackelford. The judge repeats it back, almost like he wants the court record to capture just how absurd it sounds. Without skipping a beat, he sets a jury trial date anyway. Eric looks like he's just been outmaneuvered, but he still clings to his sovereign script, ignoring how little impact it's having.
This is case 231510, People of the City of Taylor versus Eric Martin.
Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel?
Yes, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. And I don't due to canon law being, unfair. It's you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right, that's all right. So looks like this is ready to be set for a jury trial. Is that right?
Yeah, but I wanted jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So.
The bond battle begins. Eric demands an immediate personal bond as if that's how it works. He even threatens to take the judge's job, as though intimidation will sway the ruling. The judge doesn't flinch, carrying on with the bond discussion as if Eric's theatrics are just background noise. It's an early sign of how the rest of this saga will play out. Lots of noise, no real progress.
As the individual who determines questions of law, that's me, I will make sure that it is a jury of your peers. So, and I'll determine that. So, we will have this set, and then I'll mail out the date for the jury trial.
I believe there's a date set for next Tuesday for the jury trial in this matter.
All righty, I see that.
I have objections. I can probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I can probably prepare for one in here. You know?
So you're in there for a different matter, because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see it. I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date? With whatever you're doing there.
There's no out date. That's the thing. It's So is this about the moped case?
Yeah, this is driving while your license is suspended.
I wasn't sure. Right, they got me legally confined right now in the domestic violence. No evidence at all. She lied, made a statement. So now
hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case, you have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. And so I suggest not bringing up the other case. This case here is on the moped and the driving on a suspended license, or a revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case, but you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from, the, you want to call it this, the remote Zoom thing away from the door before I could read to hear. But it sounded like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, even if it's $1. So.
Eric accuses the judge of bias and demands they be disqualified. It's a last-ditch play in this round of hearings, but the judge stays laser-focused on the law. Then we shift to his second case in Taylor, and instantly Eric's back on the fraud angle. Refusing an attorney, he's convinced self-representation will somehow expose the system. Instead, it's exposing his own misunderstandings.
Judge Shackelford very clearly told you what your bond was and why it was that amount. The screen was only pulled away after your bond was set and only when you wouldn't stop running your glue eater.
I am allowed. I don't have objection to violating my right to a personal bond.
He's not to appear at 9.
Without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
So, right, because they illegally denied my personal bond, this is why I'm still in here. So, but yeah. So.
All right. So what I'll do is, I don't know when that case is next. The next day, is that a state case? Ms. Van Reno, you don't have that case, right?
I don't
so
know.
it must be a state. All right, and so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial. No, there will be no need to set it for a settlement conference before that. But let's get it.
I won't touch up. I was going to object before you guys don't give me a chance to talk. I object to it should be. I moved that to be stayed. This moped case till I get out of prison. Till I get out of jail here. I can prepare myself. I can't probably prepare myself.
Right, that's right. Listen.
Ask some of my legal authorities to argue nothing.
It's being set for a jury trial.
It's
from yesterday.
Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm going to set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as a date right now, I just want to put a date on the books so that we know that you have an idea. If you get out tomorrow, then you'll know what your date is. So I'm looking at, let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be, and it's only a couple weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple weeks to. It's a driving. it's a driving on a restricted license, so it's not exactly a whole lot of prep time for that. It's not a homicide case, but.
Eric goes for another grand statement. Only sovereign people can be jurors, not U.S. citizen slaves. It's an insult wrapped in pseudo-law, and it lands with the usual thud. The court keeps moving forward, but you can see the patience in the room being tested. It's not just the judge. Everyone's ready to move past the rhetoric.
So I'm looking at August 13th. Because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're going to set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's something I want to say to with the prosecutors here. Dealing with this other case that I'm here for now, I request that
not the same prosecutor. Not the same prosecutor. That's the same prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case, so that's a Wayne County Prosecutor's Office.
No, sir,
not the city attorney.
I'm talking about the case I'm in here now. I want them notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now, and also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
Because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence, and I do. And I should be suffering here in jail as a lack of evidence as a result of my and the unequal protection clause.
And that's on your other case, sir. So,
it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they don't, that's going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay? Deputy, have a good rest of your day to you and your staff.
Thank you, Your Honor.
Thank you, Your Honor.
This is the first time I have ever seen someone age an entire decade over just 3 weeks.
McMullen, case, the motion to set aside. Bring them out. People versus Martin, case 241388SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. Well, there's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under Canon Law 3228 that, that say otherwise, and there's a lot of support what I'm saying. So that's why I say what I say to the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Mission Court Rule 6.04C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last month.
The personal bond obsession returns. Eric insists he can't prepare for trial in jail, as though that argument has never been made before. The judge listens but doesn't budge, sticking to legal procedure. Eric's tone shifts from confident to frustrated, but his points are still circling the same drain. You can almost predict his next complaint before he says it.
And also, Well, go ahead and do that. And I also want to say, I ask that you give me all the time to speak, say anything I want to say, you know, instead of like shutting the court proceedings off that's happened before. Make sure I'm done with everything I have to say. But that's it for right now. But like I said, I might have to say depending on what you say in response. So.
All right, well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Before I ask that question, I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing, it's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to my ruling. I'm just asking the reason. I'm not asking what are the reasons that the bond, for example, is denied? Okay, first of all, what reasons is it being denied? I've already stated that last time, sir. So are we at the next question here is, do you want a bench trial or a jury trial?
Well, I have more to say in response to
do you want a bench trial or a jury trial, sir? Stop avoiding the question.
Not as much take off, jury.
Jury trial. All right, we're going to set this for a jury trial.
But I want to make it clear, I'm not consenting to
You'll be given notice of when that will be, sir.
Okay, I'm not consenting to the jurisdiction of the court still, and
Here comes the gotcha moment. Eric claims unfair $2,000 bond, but commentary steps in and rolls a clip proving the judge explained everything in detail earlier. It's a clean takedown. His credibility takes a visible hit, but he carries on like nothing happened. The gap between his claims and reality is getting wider by the minute.
You are subject to the jurisdiction of this court, so you live in the state of Michigan, you live in the jurisdiction, and under the Michigan Constitution and the United States Constitution, this court does have jurisdiction over this case and over you as the alleged defendant. The warrant was signed with probable cause. The warrant had probable cause. The warrant was signed. That's all that's needed to bring a charge, and it's brought in the proper place, which is here because you live in Taylor, and this is Taylor, so this is where the case would be. So your motions were denied, and we're going to set this for a jury trial. We'll be giving you the date and time of when that jury trial will be. Let the deputy know that.
That's what I mean. See, I'm not done yet. I have more to say.
We're in a later hearing, but the broken record is still playing. Eric again says he's illegally denied personal bond. He demands a new prosecutor and charges against his accuser, showing he doesn't even understand which officials handle what. The judge reminds him he's barking up the wrong tree. This is legal theater, and Eric's still convinced he's the star.